Your Honor, I'd like to focus on health. That's the word. And let me explain our position with respect to health there. The position of the Attorney General is that they would like to separate and divorce medical marijuana on the one hand from health on the other hand. And what they want to do is essentially rewrite this statute to say that a primary caregiver is somebody who, apart from the provision, the growing, the supply, the administration of marijuana, bracket, apart from that, is assuming responsibility for the health of these patients. Now, if the people wanted to enact that statute, could they have? Yes. Would it have been easy for them to do it, as Justice Baxter pointed out in the last case? Absolutely. And if they had done that, I would not be standing here in front of you today. But that's not the statute that they enacted. Now, our position is that by engaging in some marijuana, by growing, by supplying consistently, by counseling, you are serving a health need of that patient. I would say ultimately this is a case, as Justice Moreno implied, it's a case about whether the jury should have gotten to decide this question or whether the court had the power to take it away from them. Now, while we disagree about the substantiality of the evidence, the one thing we don't disagree on is that this jury was desperate to hear about the Compassionate Use Act. It's something I haven't seen in 25 years of criminal appeals. The jury asked 4 questions. First, they said, can we see the statute? The judge said no. Then they said, well, wait, under the statute, can he get his reasonable expenses back? The judge said, I'm not going to tell you. It's none of your business, the Compassionate Use Act. They asked another question about whether the signs on the walls gave him a defense under the Compassionate Use Act. At each point, the judge refused to inform them. 4 times they asked, and 4 times they didn't want it. In the end, the court did tell the jury that given the law, as I've instructed you, you had no choice but to convict Mr. Mentch. And our position, Your Honor, and that's on the record, you had no choice but to convict him given the law. And our position is that the jury should have had a choice. Thank you.
That merely supplying marijuana to a patient is not enough to qualify as a primary caregiver.
What more is required? Somebody is ill, has a prescription, wants marijuana, goes to this person, who thereafter consistently is his provider.
I think, you know, in the broad context, if you were to say, okay, supplying somebody a medication that is necessary for their health, that could be perceived as providing something necessary for their health, in the broader context of things. But here, within the context of the Compassionate Use Act, you have to establish that you're first providing caregiving before you can even engage in that activity. So, in this case, for instance, the first time appellant sold marijuana to a patient, he was engaging in illegal activity.
Well, how can you first provide caregiving if the patient isn't ill, so there's no occasion? Then comes the patient who's feeling ill, gets a prescription, and you provide it.
The problem is, in that instance, if a patient does not have, if they don't have any need for a primary caregiver, the statute allows them to grow their own marijuana. It doesn't allow them to.
What if they don't know how?
Unfortunately, that's something the Compassionate Use Act did not address.